Good morning, ladies and gentlemen. Good morning, everybody. My name is Tebi Tsengiwe. I am the Chief Communications Officer at Old Mutual, and I have the honor of seeing to today's proceedings. I would like to thank you all for joining us and making the time to be with us. Welcome especially to members of the press, but more especially to the Old Mutual Limited board, as well as members of our ExCo. My role today is really simple. If I can just run through a little bit of housekeeping. The ablution facilities are through that door. You can either go to your right or to your left, right to the end of the passage. I would also like to request at this time that we all switch our phones to silent mode, please, so that we are able to all hear each other. And if there are any parking vouchers that you got coming in, please let us know, but you should have had free access to our parking space. So we will just make sure that you are able to get out of the building without any complications. I actually realized when I woke up that today is Friday the 13th. Not that that means anything, but I'm sure that you have all been in a space where you would like to hear from the Old Mutual chairman himself around what you have been writing about in the media. And so I will not take up much of his time. I will now hand over to Chairman to give us an update on where we are on the Peter Moyo case. And thank you very much, Chair.
Thank you very much, Tabby. Good morning to all of you. I don't support Liverpool Football Club, but there's a song that says "You Never Walk Alone," which is actually very appropriate. We have here a number of non-executive directors with me. Well, also one executive director who's just come back from Boston. But Marshall Khapia, Ian Williamson, who is the interim CEO, Peter de Beyer, Paul Beloy, Stuart van Graan. Of course, this is not the board. This isn't even a representative sample of the board. The board is certainly not this gender unfriendly. But the call came through yesterday, and because we are non-executive directors, I think it's in the nature of what we do that people are normally occupied. So we have a calendar that will take us now into 2021, and so those dates are set aside for us. In the front here, we have a number of the ExCo. I want you to look at them because I heard somewhere that black people are scared of Old Mutual. I want you to look at the ExCo and confirm this thing. But we haven't come here for that. I want to welcome you and just explain, firstly, that we have a team of 14 non-executive directors, 2 executive directors, Ian and Casper Trotsky, who's our financial director. That's the board of Old Mutual. This board was elected by shareholders on Friday, the 24th of May. And we are there as the representatives of shareholders to act in the interests of the company, and they will hold us accountable for what happens in the company. But of course, we take a very serious view of our entire responsibilities. So whilst we have that immediate line of accountability to shareholders, we are actually responsible to all of our stakeholders. So our stakeholders include all of the employees of Old Mutual across the African continent. They also include, very, very importantly, our customer base. And when we consider matters as the board, we consider this across all of our stakeholder base and what's very important in the way in which we take decisions. We know that Old Mutual is one of the oldest companies in the world, and it will remain, and our responsibility is as custodians of this old company to ensure that it has durability into the future. So this is not a short-term battle. This is about the future of the company. It is about responsibilities and values, and that is why these matters are as important to us as they are. Now, some people, some amongst you have have wondered about the fact that I've been silent and I haven't been on mute. There's a particular reason why we've dealt with matters in the way that we have. You see, in the course of this litigation from about the end of June, there was this notion that there are two individuals. This whole thing is about two individuals. And the board said, but this is not about two individuals. It's never been about the chair. It's been about the board taking leave of a chief executive. That is the theater of what has played out. And so for the chair to be placed in the media on a daily basis actually is likely to amplify something that is fundamentally untrue. And the board, in its wisdom, chose various of its members to communicate. Paul Baloy here has communicated with some of you. Peter Moyo has communicated with some of you. And Nombulelo Mohodi, also known as Pinky, has communicated with some of you. So the board has a very wide purview, and it's quite important to recognize that the information base that we have and the decision-making about these issues places in a position as equals and essentially having interchangeable information. We understand the rationale for why this perception was created that it's about me, but we can deal with that later. Also, I want you to look at these board members and know the others. You can go online and see their pictures and ask about them, and you will understand that these individuals could never be bullied by a person like me. You know, Marshall Khapia here, if you know Marshall, you will know that it's so far-fetched. So that's the first issue. This board is united in purpose, and we're here for the long term. The second set of issues that we have to deal with this morning is why we opted to separate from the chief executive. Now, the board had expressed this, and in fact, I was surprised. Our competent company secretary here had deposed an affidavit in the matter on behalf of all of us. Why the company secretary? Because she is always present. She or people who report immediately to her are in every meeting of the board, subcommittee, etc. And she is the most senior official of the board, and she deposed the affidavit. And it's a very clear exposition of what transpired and how we got to that point. The tragedy is, I think, too few people have bothered to go online to access it and read it. But it sets out everything. Because what it does, what that affidavit does, is to explain in some detail how the breakdown of trust and confidence developed. It wasn't something that happened on a single day. There was a process. It was pretty detailed. It was a process whereby we listened to each other. It was a process that intensively worked through December, January, February. It got lifted. March, it got lifted even further. And the people who were involved in running the process until that point was a board committee called the Related Parties Transaction Committee. There's one representative of that committee here, and that is Stuart van Graan. And Stuart would be able to answer questions in the detail to the extent that it's not privileged and confidential information. But there was a very detailed process that allowed us to hear each other. The board in March gave approval for lawyers to try and get certain information from a company where Peter is, of course, a shareholder called NMT Capital and NMT Group. That then set in motion a process of securing information. And at that point, at some point along the line in April, Peter was engaged. In fact, he was engaged from February already, but from April intensively, he was engaged in the process. The board was very concerned when it came across certain information that hadn't been given to it. It came across that information with approval and discovered that things had gone horribly wrong. The board met on the 1st of May, discussed the issue in great detail. Another decision was taken on that day, and that was that whereas we're a 20% shareholder in NMT, we should separate them out, and they were informed of that by letter on the 2nd of May. The board on that day put together a committee of 4 people to try and meet with Peter because there were conflicting reports of where we were. 3 of those people are in the room, Stuart van Graan, Paul Beloy, and I. We met with Peter from the 2nd and tried to establish what the basis for information is. And we couldn't reach satisfaction, and so later, and you'll find this in the court records, on the 16th of May, we gave him a letter asking for further information. I gave him a few days to respond. We looked at the response. We took it to a committee of the board, which is called the Nominations and Governance Committee. It was taken to the board eventually on the 23rd of May. Peter was invited in to explain the gaps in information, and then it triggered a series of issues, including the decision by the board to suspend him on that day. Later, he appointed a firm of attorneys. They acted for him. There was some exchange of information between them and their attorneys, between them and us, that firm acting on his behalf. And then we dismissed him with effect from the 17th of June. And 10 days later, we received notice of motion, and the matter was then in court. It was never the choice of the Old Mutual to have this matter in court. In fact, on the 24th of May, we spoke to Peter about this break of trust after we'd heard him out. And Peter Dubai and I were 2 of the 3 members of that committee. And we asked him, we explained this thing to him and asked that we manage this thing in an orderly, disciplined way so that it didn't impact on any of our futures or the future of the company. That was not responded to in the way that we'd hoped. And then we ended up, as I say, from the 27th of June in court. Now, I want to deal with those matters in just a bit. But of course, there are a series of issues that you need to be mindful of. Peter's contract of employment was signed on the 31st of March 2017, and it sets out a series of operational matters, including his accountability to the board, and then a short line of communication between him and the chair of the board. We were all aware of his investments in NMT, and for that purpose, a special protocol was designed to govern his conduct. Now, it's a matter that has been debated in the public domain, so let me just say that the protocol was designed to govern the conduct of the executive, Mr. Moyo. There was another director on the board of NMT. But if people familiarize themselves with the Companies Act, they'll understand that that person's primary responsibility, fiduciary responsibility, was to NMT. He's no longer with the Old Mutual, but his primary responsibilities were to NMT. Now, there's this narrative that goes, but it was his responsibility. That's not in the documents the way we read it. The protocol was designed specifically to deal with a conflict that presented in respect of one individual. And it was in the fact that that conflict became unmanageable that the board then had to take that decision. The unmanageability related to the fact, and again it's something contained in Elseby's affidavit, that Old Mutual had preferential shares outstanding. There were big arrears on the preferential shares, and there were ordinary shares. And the dividends had to flow. But before the dividends on ordinary shares had to flow, in terms of the law, you've got to deal with the dividends on prefs. And the prefs had, in fact, expired by the end of June because of legislative changes in respect of the Insurance Act. And thereafter, in fact, 3 days thereafter, Peter Moyo chaired a board meeting of NMT. They just had a big payout from the sale of Growth Point shares. And instead of dealing with their obligations, they actually decided to distribute 105 million rand as ordinary dividends amongst the 4 shareholders, effectively, one of them being Old Mutual. Now, you've got to do the maths on what this means for the individuals who are shareholders. I don't do mathematics or arithmetic. But the question was that whereas the employment contract says we recognize that there would be dual loyalties, but in matters relating to the Old Mutual has to get precedence in the way in which you do. It's there in the contract in black and white. There's nothing to debate about it. And when you put money in your pocket and leave the needs of Old Mutual aside, there's an unmanageable conflict of interest, and that is what this issue is about. So let's move on to June, July, when this matter then is in the courts. And there's a rather peculiar change, because with the previous attorneys, there was a line of communication about what the matters were in dispute. And with the new attorney, Mr. Eric Mabuza, supported by senior counsel Dali Mpofu, there were suddenly issues that were never part of the discourse. The first of those is something relating to me and legal fees. Now, I know that some people have this view that I've treated Old Mutual as a piggy bank for legal fees. Let me just share with you, in the course of this year, I've had to use lawyers, outside lawyers, thrice. Once to appear before the Zondo Commission. Once in a matter I instituted an action for defamation against the EFF, and once in response to a notice from the public protector relating to my previous life. For all of those, they are for my account. I can't go anywhere else. I can't even go to the government that I served for 20 years and ask them to deal with matters that arose from my tenure as a minister. It's for my account. There were 2 matters, and I'd like in a moment to ask Peter Moyo to explain these matters and how they came about, because there was a request in 2 matters. The one is a PAIA application. It's a procedure for access to information under the Procedure for Access to Information Act, and it arises from the Gupta leaks, and it arises because I was traveling into and out of the country, and private citizens had control of my movements, and the Old Mutual out of London thought that this is an untenable situation. The second matter relates to a former minister, Nomvula Mokunyane, who went on a ENCA and made all kinds of outlandish claims, which when on the Justice Malala show, if you must, when the transcript was sourced by legal department at Old Mutual, they were then able to ask her to retract, and that created a legal matter. It had nothing to do with Trevor Manuel. It was actually distinctly an Old Mutual matter. But there are those two issues Peter will explain in a moment, because I was recused from the meeting that discussed this issue, and you chaired it, didn't you? So that's the one issue. But there's no foundation in truth about what happened. And there clearly is no foundation in truth about it being a whistleblowing or act or something covered by the Protected Disclosures Act. There's no trace of that at all. So how it arrives in court papers, I don't know, but it's unlikely to be a truthful thing. The other matter that arises in the same court papers is called a triple conflict. And again, you know, Peter, you have better knowledge of that than I do because you were involved, whereas I wasn't. But for your own satisfaction, I will again invite you to read LCB Kirsten's responding affidavit, because the matters are set out there in detail about which meetings I attended, which meetings I didn't attend. But I think there's something bigger here. You know, before our listing last year, we had to prepare something called a pre-listing statement. Every board member knows that that document is 558 pages long. And that document was perused, internalized by every board member. In fact, in quite an uncanny way, we did a page-turning exercise on that. And we took it through those routes because each of us had to attest to the veracity of the information in that pre-listing statement. Now, to suggest later that there's a triple conflict not covered by that pre-listing statement must surely suggest that at one of 2 points, because one of the signatories to the pre-listing statement is Peter Moyo, like I am and each of us is. He was either untruthful when he attested to the pre-listing statement, or he was untruthful when he submitted an affidavit to the court about a triple conflict that had never been raised before. Now, these are the matters before the courts. And as you would be aware, Judge Brian Mashile, the Honorable, handed down judgment on the 29th of July. We applied for leave to appeal on the same day, and 1 week ago today, he granted that leave to appeal. So his judgment is subject to appeal. It's not ignored. It's not ignored. It's subject to appeal. You know, if legal action didn't, if it were required to be enacted immediately, I would have had 500,000 rand now from a certain political organization. They haven't paid me my 500,000, even though the court said that they have defamed me because they want to take the matter to the Supreme Court of Appeal. And I will wait because I want to go and find those aunties who'd banked with VBS and say, here's your money. I'm saying you've got to wait until the appeals process is done, and that's what we're doing. And I've heard people say, but we're ignoring the courts and we have no respect for the rule of law. We have respect for the rule of law and the rights that it creates for parties in a matter, and that's what we're doing. And that victory last Friday in being granted leave to appeal is fundamental to us because we believe that we will be afforded an opportunity to set the record straight. So, one of the things we did, and it's also, well, it's not actually the subject of a court action, but Judge Mashile on the 29th of July said, you dismissed Peter in terms of one section of his contract, section 2511 or something like that. 24, section 24. And the way in which the contract is designed, if you going to dismiss somebody in 24, and you did give him a hearing, but you didn't have a formal disciplinary inquiry. But if you had dismissed him under Section 2511, then you could just have dismissed him on notice, saying, there's your 6 months' pay, bingo. And so if the first notice was defective, and we don't think it is, we corrected that on the 21st of August by giving a second notice that says, in terms of the relevant section of your contract of employment, you are hereby reminded that you are no longer an employee of Old Mutual. They went to court last week on all manner of issues. They went to court in a way that included, how could Peter Moyo say nasty things about him on television? Why did Paul Baloy say unkind things about him on television? Why did we issue a notice to an open letter to our shareholders, as though we'd been gagged at some point, as though there's an asymmetry in access to communication? What we did was to communicate as we should. And so in all of that fanfare, they ignored the fact that there's a second letter, which in terms of the decision by Judge Mashile is perfectly legal and valid. That's the position. That's where we stand. Tabby? Oh, Peter. Thanks.
Thanks, Chair. I'll just deal briefly with the two matters you asked me to deal with. So firstly, in terms of the two legal matters relating to the chairman, we in the Nomination and Governance Committee and in the board were brought an application or a proposal which had been prepared by Craig McLeod, who's sitting here, our Chief Internal Legal Counsel, and it was introduced by Peter Moyo as the Chief Executive, seeking the board's approval to ensure that we endorsed the fact that we took over the matter on behalf of Old Mutual, because Old Mutual's interests needed to be protected, and that consequently all the legal fees for those two matters would be for Old Mutual's account. After considering the matter and looking at the merits of the case, the board agreed, and of course during this period the chairman had left the room and was recused from the discussions, and the board came to the conclusion that it was indeed sensible for us to deal with these matters for Old Mutual, and in our opinion this was a matter that was a normal business expense for Old Mutual because Old Mutual's interests were at hand. Obviously there's always an issue when anything is involving any of the directors as to whether or not there needs to be special disclosure of that particular item. We noted that, and the question arose, and it was referred to our internal accounting experts and our internal tax experts, and they in turn would have taken their view on the matter or their decision on the matter for review by the external auditors. As a result, because this was deemed to be a pure, normal Old Mutual business expense, there was no disclosure required, and the matter was not put into our financial accounts. Now, it's very important for everyone to know, when one sees what has been said out there, at no stage during this entire process did Peter Moyo ever approach the audit committee through all of its meetings at which he was present, or the board itself where we signed off the financials, or the external auditors, or any of the individual board members involved with any contention around whether this was a disclosable matter or not. So if he did feel that it was a disclosable matter, those were the forums in which he had to raise it, and he did not, and he then, along with all the other directors, signed those financial statements without the disclosure. The second issue is around the so-called traveller's matter, which is a long-standing warranty or guarantee that Old Mutual PLC had given as a result of its investment, which since was divested in F&G Life in the US. As part of the managed separation, all of the legal arrangements that PLC was involved in had to be dealt with, and there were a multitude of these, and this was just one of them. The particular party who were the ultimate beneficiaries of that guarantee were Travelers Insurance, and they saw an opportunity to maybe get something for nothing. As a result, we had to deal with this matter, and we had to make a decision whether or not Old Mutual Limited would take over the ultimate liability for this matter. Now, it sounds like a lot of money because the face value of this thing is $480 million. That's the cap at which is set. But when one goes through it, in order for any liability to have been incurred by either Old Mutual PLC in the days when it had it or now Old Mutual Limited, all of those particular customers which have been in existence for a number of years with F&G Life would have to claim. A whole series of reinsurers and companies that insure those people would have to fail, and only then would there be some possible residual liability for Old Mutual. The risk committee, of which the board chairman is not a member, considered this matter in detail. We had voluminous legal papers and also actuarial papers to make our decision. We came to the conclusion that taking on this liability was both a sensible thing to do in terms of the fact that the residual liability was so small despite the very large potential face value of this thing. This was a unanimous decision of the risk committee and a unanimous decision of the board, supported by papers. The chairman was not specifically involved in that decision. None of the board members saw this thing as significantly contentious because it was exhaustively dealt with. And the fact that this was a transfer of liability ultimately from Old Mutual PLC to Old Mutual Limited was one of many sensible transactions that was part of the managed separation. And again, at no point was it ever raised that there was some issue with dealing with this. And again, this is an item that was fully ventilated in the pre-listing statement, and all of us signed up to it. Thank you, Chair.
Thank you very much, Chair, and thank you, Peter. We do have people who have joined us via webcast, as well as people who are on our chorus call line. We are aware that my colleagues, members of staff, are watching this via web stream. Right now, I am going to open the floor to questions, and I will plead with my colleagues who are online and on the web stream to please allow the media to ask questions, because this is primarily a media conference. There is a plan for us to do a roadshow. So there will be a roadshow that is facilitated through EXCO, where our EXCO, together with members of our board, will be going to all of our offices across the country. So if I may plead with our staff to please hold back on questions for now and allow the media the time. Before we go, I would like to say that I will take the questions in clusters of 3, and I would like to please request if we can keep our questions as tight as possible to members of the press, please. And if you would start off by identifying who you are and which media house you represent. I will now hand over to the floor for questions to the chairman. Thank you. And members of the board.
Angelo Coppola from China Global Television. Mr. Manuel, 2 questions for you. One, why was this letter issued today? Can you just give us some background as to why you decided to come out with the letter today? And secondly, practically speaking, what happens to Mr. Moyo now? He's a stay-at-home dad, essentially. Looks like he's not going to be coming into the office. Explain how that's going to work on an operational level.
Tabby, how would you like?
I would like us to take 3 questions at a time, please, Chair. 3 people at a time. My apologies.
It's Ray Mahlaka from MoneyWeb. Some shareholders have come out saying that the management of the first suspension and subsequent dismissal was handled poorly, despite there being a protocol set up to manage the apparent conflict of interest. Some shareholders have said that the board needs to be fired or resign itself. So, Mr. Manuel, I'm just wondering from your side and your colleagues as well, do you think those calls are warranted, that the board should be fired for its handling of this matter? The second question is about Judge Brian Mashile's judgment. He did say that the protected disclosures did influence or have an influence in the firing of Mr. Moyo, that is. And so Mr. Moyo still believes that he is a whistleblower, basically, and that led to his sacking. I just wonder, what's your response to that? Because it does seem like, if you look at the sequence of events, that according to Judge Brian Mashila, that the protected disclosures did play a role in his sacking. Thanks.
Thanks, Ray. We have one question on this side.
Hi, Lainey from Bloomberg. I'm just wondering, what will the liability be of for Old Mutual by disinvesting in Peter Moyo's company, NMT Capital? I know you guys took a bit of a write down, 100 million rand before. So I'm just wondering, do you think it's going to be a fire sale, or would you be able to disinvest in an orderly sort of sales process?
Thank you. I'll hand over to Chair and any member of the board to take those questions.
Okay, thanks. Angelo, the question about the letter is, I know that it's created a bit of confusion, partly because social media frequently misinterprets things. The one thing that we are abundantly clear about is that we've got to see the legal process through to its conclusion. We have been in conversation with the Judge President of the South Gauteng High Court, Justice Dunstan Lambo. He has given us a window of dates to conclude this process. And we will, in fact, he set out a whole series of dates in that communication about by when he expects papers to be served and so on for this. So that process is continuing. I think, having said that, it's also important that I repeat something that is quite fundamental to the way in which we've seen this. We haven't wanted to be in the courts, and we don't want to continue in the courts forever and a day. I think that we look at the appeal opportunity with a great deal of confidence, and perhaps that changes the matter for all time. But the matter must come to a conclusion. That is fundamentally important for everybody associated with this, certainly on the inside of Old Mutual. The share price needs to pick up, and I think people need the confidence. Which is why I'm saying our interest as the board, along with all of the stakeholders, is a long-term interest. There's no glory in getting into a sort of street fight about something as though it'll end tomorrow. Your second question?
Around the status of Mr. Moyo going forward.
And he has. And has. He was an employee. He was an employee from, I think he joined us effectively 1st of June 2017. He was previously an employee of Old Mutual. In fact, Marshall, Ian, and Peter sitting together were close colleagues of his. Peter and he were joint deputy MDs of this company. He left to proceed on his own. He came back in 2017. He has received his notice pay. I think that concludes the story from our perspective. No, I don't know that. I don't know that. There was some proposal from his lawyers that he work at home. We must re-employ him and that he will work at home and so on. But that has never been through the mill on our side. No. Well, he can come back and he can have coffee on the ground floor. If he has a meeting with any of the staff, he can use one of the boardrooms on the first floor. But unless you are employed in the building, you don't have access to the building. It wouldn't be a uniquely Old Mutual thing, nor, Heidi, a uniquely Peter Moyo thing. If you came to the building like you did when you interviewed Mr. Baloy here, you were escorted because you had a purpose there. You know, no purpose, no entry. Ray, you know, the question of the handling, there'll be a number, this is a legal matter. And I'd like you to find circumstances where you get 3 lawyers to agree to one position. The purpose of having law and lawyers is to create opportunities for differences of view. I've tried to walk you through how this process unfolded, sparing you the detail of hundreds of pages of exchanges on this matter. But I mean, I think that the board would remain of the view that we handled it as best we could. The second issue is, you know, I see this occasionally. I don't know why I do this. I really shouldn't do it. I shouldn't read anything. I shouldn't read newspapers, certainly, not even online. But I do, and I check the byline, and I see where people are coming from, and I see repeated stories like that. But I also know that we were elected with very, very, very substantial majorities on the 24th of May by our shareholders. I know that we have engaged all of our shareholders. We receive letters from our large shareholders, and our largest shareholders, the largest shareholder now is Alan Gray. Second largest is the PIC. We have offshore and onshore shareholders, and they write to us about matters all the time. So I read those views, and I also have a click meter that tells me how many times the same story from the same individual is repeated. But they haven't, in any engagement with us, raised it.
Pension fund shareholders, they've raised this issue that the credibility of the board has been compromised throughout this process. So is it your belief that the board in its current composition should remain as it is?
Unless there is just cause for the board to step down. Bear in mind, we don't have a permanent chief executive at the moment. The Companies Act makes it abundantly clear, Ray, that shareholders elect directors. We were elected in May for a purpose. If shareholders don't want us to be directors any longer, they express that by voting, whether direct or by proxy. There's established practice for it. And I think I would prefer to deal with it in that way than those who shout the odds when there are 0.000 something % shareholders in the company. Your third question was about whistleblowing. Now, I don't want to delve too deeply in the views of Judge Mashile and how we arrived at it. But I think Peter Moyo expressed this thing in some detail. He was present, I wasn't. But what I do know, because I'm familiar with the Protected Disclosures Act, that I can't find any cross-reference. I know that we've got an off-site hotline where whistleblowers report, and we never know, because it's an anonymous hotline, we never know who reported, but we know what the subject matter is. And I've asked the people who manage this to tell us whether there was anything like this on the whistleblowing line. There's a whistleblowing line, there's a fraud line, and so on, and there's been nothing. So how do you claim status that doesn't exist? Even if Brian Mashile, sorry, the Honourable Justice Mashile, thinks that these matters were sequential. I mean, I was relating stories because in the same affidavit you would read about all hell breaking loose, and the number of times that Peter and I met in public places, as we normally did at least once a fortnight. Between that date in March and almost to the end of May, so I find it quite bizarre. Sorry, yeah?
Please clarify something. So what I'm meant by the protected disclosures is that Judge Brian Mashiles found the timing of Mr. Moyo's suspension and dismissal suspect because the timing at which he raised questions about your alleged triple conflict of interest and the legal fees as well. So Judge Mashile questioned the timing of those sequence of events that ultimately led to his separation.
Mr.
from Old
Mashlaka,
Mutual.
let me repeat that we are appealing the entire Mashile judgment handed down on the 29th of July. You see, as Peter de Baye here explained, the issue of a triple conflict was never, ever ventilated within the confines of the Old Mutual. If anything, Peter Moyo signed, and I'm sure if I asked Elsie now, she would be able to give me the date that he signed the pre-listing statement when he confirmed that there was no conflict, that was not recognized in there. My directorship of Rothschild, for instance, is recognized in the pre-listing statement. My directorship of then the PLC and OMEM is recognized in there. So unless there's a track of it, I think that I find it very hard to believe because Elsie's affidavit says on this matter, it seems like an ex post facto creation. Craig, sorry.
Chair, if I could just also interject at this stage. Craig McLeod. Ray, if I could ask you just to also go and read both the main judgment as well as the judgments on leave to appeal. You will find a quotation in there from Judge Mashile where he says that any relation to the protected disclosures issue is the most insignificant part of that judgment. So I'd ask you to actually go and read both judgments again. I don't think there's a firm finding on Judge Mashile's judgment. And to close out in the main one, he talks about factual causality in an interim urgent application. So I think from a legal finding perspective, I think your statements may be a little bit overstated. Yeah, but I think you are putting further more influence on it than it is. He's brought it particularly back to a contractual interpretation.
Okay.
Thank you.
No, there were the questions. I didn't get your first name. I know you're from Bloomberg. Yeah, it's Lowly. Lowly. L-O-N-I. Oh, Loney. Yeah.
It was about NMT, Chair.
Yeah? Yes, I know. No, Ian, are you in a position? Oh, I saw Casper come in. Where's Casper? Oh, there he is, hiding, in the shadows. Casper is our finance director. Casper and Ian are actually on a roadshow at the moment. They've just returned this morning. Casper, did you hear the question from Loney? The question is, the sale of the NMT assets, would they be done in a fire sale or is there an expectation?
Chair, we need to distinguish between the NMT capital, which is where we had the payment of the dividends, and NMT Group, where we have a much larger holding and where over time there have been some impairments. We have disclosed fully the amounts outstanding in our interim results. It amounts to about 291 million. It's split between NMT Capital and NMT Group. We're all aware that the NMT Capital portion, which is by far the smallest amount owing to Old Mutual, has been repaid, and we'll assess whether we need to make any adjustments to the NMT Group values as we work through that negotiation. At this stage, we're not planning to make any big write-downs.
Sorry, you had a second question, Loney. That was it. Okay, cool. Thank you.
Thank you very much. Ladies and gentlemen, I'd like to take the next set of questions, please. Lisija. Yeah.
Thank you. I'm Londiwe from Business Day. My question relates to your comments about not ignoring Judge Mashile's judgment and saying that it's because it is subject to an appeal. And but the last Friday's ruling actually said that while you're appealing this matter, Mr. Moyo, you ought to reinstate Mr. Moyo. So I want to understand, how is that not ignoring that clarity that you were given on Friday? I know that the matter is under appeal, but he said while appealing, he ought to be reinstated. And then another one relates to just Mr. Moyo's status, and you've touched on that about you don't know Angazi where he stands. But the letter, I just went back to the letter now to read, a bit more to find clarity on what exactly it said. And it said he has expressed that he is obliged to render his services at Old Mutual, and he continues to do so. But he's not required to go back to work. It's the letter from Bowman's, the lawyers. So it says he's expressed that he wants to do that, and he continues to do so. So for me, it doesn't tell me, is he still an employee of Old Mutual, or he's not, because there's that second dismissal, which on its own, you were going to go seek clarity on whether it is valid in court, but then you've taken a stance not to do so. Thank you.
Thanks.
Okay. Leseja Malope from City Press. I only have two questions. The first one is the body unanimous in this stance that you must pursue the matter further against Mr. Moyo, considering what's at stake once the entire board declared delinquent? Is the entire board, do they agree on the stance? The second question is, what is the point of having executives here? Because if this thing goes south, they're going to have to work with Moyo directly.
Okay. Any
other questions?
It's okay. Loniwe, I'm going to ask Craig to go into the detail with you. But let me just tell you, apropos your second question, I've expressed many desires in life, but they just are my desires. They may not accord with the facts. So how do you read anything into the expression of desires? But Craig?
Thanks, Chair.
Oh.
Thanks, Chair. Londiwe, your question is about the Mashile judgment that was handed down, that is now the subject of appeal. The Section 18 application and declarator that we've received a ruling on Friday past effectively made it clear that whilst we got leave to appeal, the original order reinstating Peter Moyo to his position as CEO would not be suspended pending the outcome of that appeal. What's changed in the interim, and I think you touched on it in the final question, is that prior to the judgment on the Section 18 application coming out, Old Mutual and it's the Board of Directors of Old Mutual issued a second termination notice on the 22nd of August. And Old Mutual's position is that notice is distinct from the first notice that was granted and remains valid in law until such time as a court sets it aside. It was not before the court on Friday past. It is one of the bits of evidence that Mr. Moyo seeks to introduce into the court proceedings when he wants to reopen the contempt proceedings against the board. But what was not before court was an approach to have that second notice set aside. So from Old Mutual's position, sorry.
Okay, just on that issue, so the content of court hearing last Friday included that to say this is another contempt of court by having a second dismissal. So it was part of Friday's hearing. It was part of contempt of
So,
court.
so
I
just to
don't-
be clear, just to be clear, Friday's hearing, remember, on the Section 18 application, pleadings had closed, the matter had been argued. What was awaited was Judge Mashili's judgment. Post the second notice being issued on the 22nd of August, Mr. Moyo approached court to have the argument, the matter that was before Judge Mashili reopened to introduce new evidence. That is the ruling that is outstanding before Judge Mashili now, and that is what we're waiting on, and he says he'll do it in the next 2 weeks. If you go to the particulars of claim around that particular matter, you'll see that Mr. Moyo first needs, or Judge Mashili first needs to rule that further evidence will be allowed into court, and the parties will be able and entitled to file replying papers in response to Mr. Moyo. Our Mutual's position remains that that second termination letter, whilst it may be part of what he wants to introduce as evidence of contempt, that does not at this stage set that letter aside, and Judge Mashili certainly hasn't issued a ruling at this point to invalidate the second notice.
Thanks. In fact, there isn't a request even in that late application to open that seeks to invalidate the second letter of notice. There are all manner of bells and whistles, but nothing that relates to that in particular. Lesetja, your first question was about the reinstatement, and I think that Craig has dealt with that largely. No? Yes? No? Oh, unanimous.
The board being unanimous, Chair.
The board is entirely unanimous about this. There's no individuals in this thing. The board is solidly behind what has happened every step of the way. Now, this brings me to your second question. And so let me invite you to visit the Old Mutual Limited website and look at the track record. And I'm going to exclude Ian Casper for a moment because they're executive directors, of the non-executive directors. Each one of us, maybe the other 13 more so than me, have deep experience of issues relating to governance and corporate affairs. Now, I want you to exercise your mind about the hurdle that you will have to clear to have 14 people declared delinquent. There's a very real objective test that the court will have to apply in the instance. It almost seems easier to deal with one person than deal with 14, but I'm not suggesting anything. Because I think that there's a massive hurdle that has not been articulated, and merely because you've seen it in the papers doesn't, I think, give it a snowball's hope of hell of being realized. It's a strong language I'm using, Lesetja, but you've got to look at the facts before you. Also, I mean, just bear in mind that you can't, you see, because one individual is upset about these matters, you can't transcend the impact of corporate governance as set out in the Companies Act. That still remains. And that says that shareholders elect directors to represent their interests. So you can't take shareholders out of play in this engagement. It would be pretty far-fetched to get there. Thanks.
Any further questions? I will take the last set of questions from the floor before we go to the line. Sorry, Lesetja? Sorry, Chair. The second question was about the executives being unanimous and
No. The second question was
would have
about
to work.
what's the purpose of having executives here? If this thing goes south, they're going to have to work with Moyo directly.
So will the board. So will the board. He has accused this board, these individuals, and I'm saying, go and look at them. And I said of Mr. Khapia here, do you think I can bully this man? No, you've got to start with the board. The accusation, no, go back to the papers, Lesetja. He says that the board are bullied by me and they have no views. Yes. Well, mamela. He says that this board is delinquent. You ask the question. And unless the board vaporizes, he will have to come in and work with this board that he says in court papers he has no respect for individually and collectively. I'm saying you haven't gotten rid of the norms of corporate governance as set out in the Companies Act. So how will he get there? So before the executives even, I mean, these executives, the EXCO members here are all adults with a lot of experience in own name and right. And by not having them here, they're not going to walk around with earplugs so that they don't know what's going on. They have views on this matter and they are vested. They are representatives of 35,000 employees in this company. They are fundamentally important as a stakeholder group. You can't wish them away.
My name is Konati. I work for Daily Maverick. So I may ask a question that is...
Are you allowed to be here? No, it's okay.
Please pardon me. I may ask a question that has already been asked. I had to attend to other duties outside. But can you tell me, how did Old Mutual's representatives vote at that meeting where a dividend was declared to the shareholders of NMT Capital? Secondly, the board so far has not been winning court cases against Mr. Moyo. Isn't it time perhaps you should just sit down and talk and find a way to save this company so much unwanted publicity and embarrassment?
Okay, Skonati, thanks. I thought you were going to ask about ESCON. No.
That
no
too,
longer.
sir. When are you becoming chief executive?
Look, there is a curiosity about the chap who was the last director of Old Mutual on NMT. His name is Mobashir Patel. It's not a person I've ever met. And if one of you said that he's Mobashir Patel, I would have to take your word for it because I don't know Mobashir Patel. He no longer works for Old Mutual of his own volition. Now, let me come at the issue a little bit differently. Until recently, and from the time of managed separation, Peter Moyo was on the board of Nedbank as an Old Mutual representative. And we had discussions about this, and the interpretation of fiduciary responsibility drawn from the same Companies Act is that he owes his duty of responsibility to Nedbank where he serves. And so Old Mutual, he didn't come back and say, look, we discussed this and that, and these are the minutes of the meeting. He owes his duty, his fiduciary duty, to the company that he sits on. And so I'm sure that Mobashir would have dealt with it in the same way. I don't know if because this matter was escalated late in the process, because normally these things are dealt with somewhere below in the labyrinth. The circumstances changed with the listing of Old Mutual at the end of June last year, firstly. And secondly, the employment of Peter Moyo actually created a related party matter. And related parties is also something well canvassed in the Companies Act. So the nature of that relationship changed. I don't know, because I'm saying I've never met Mr. Patel. I don't know whether somebody took him aside and said, the nature of the relationship has now changed. You have to prepare reports to Old Mutual. I don't know whether that happened. The second point I'd like to raise about this is that Part of the difficulty of that relationship is that there was a reporting line for Mobashir Patel that would eventually end with Peter Moyo. It's very difficult to take decisions. The third issue is that the relationship was actually not primarily with Mobashir. I said in response to a question earlier that the entire protocol was created so that Peter had a line of accountability. It says in his letter of appointment, you will be accountable to the board in general, and you will be accountable to the chairperson of, it was still Old Mutual Emerging Markets then, for day-to-day matters. The protocol was about the conduct of the executive concerned, and that is Peter, and his responsibility to report matters. Which is why when you look on balance of whether he was exercising the interests of Old Mutual, chairing that NMT board meeting or not, I mean, it's that you have to work through. The other issue, which is very interesting, because we try to get to the root of this, and again, there are people who are more knowledgeable than me, because I've never been part of the Related Parties Committee. I think that the minutes of the meeting of NMT of the 3rd of July last year were kind of signed in April this year. But by the time those minutes were signed, we don't know what happened to Mr. Patel. You want to speak to that?
If I can just clarify that the minute you're referring to, you're right, came through this year, is part of the court papers. And what it does reflect is that the chairman proposed the dividend be declared, and it was supported by the two other individual shareholders. Mr. Patel's name is not on there. We don't know what happened at that meeting, but that's the minute that's part of the record. And I think that's as far as we would be able to take it. Happy to make a copy of the minute available if it's necessary, but it is part of the court record and in the public domain.
The answer to my question is that Old Mutual does not know how its representative voted when that decision to pay dividends to NMT Capital was made.
So let me qualify what you're saying. The Old Mutual nominated director, not representative. We have no knowledge of how he voted in that meeting. He certainly didn't come back, as the chair said, to report on us on NMT matters and affairs. Those were in terms of his fiduciary duties that he would owe NMT as an NMT director. What we do have is a minute that's been produced by NMT of that meeting, which effectively says that the chairman, the person who chaired that meeting, Peter Moyo, proposed the dividend be declared, and that proposal was supported by the other two individual directors.
And it's silent on the nominee.
It is silent on any involvement from Mr. Patel. Mr. Patel's no longer in our employ.
But he's a director of NMT nominated by Old Mutual and therefore was representing Old Mutual's interests in that particular meeting.
Not in law. In law, you are nominated by a shareholder.
Sure.
You are appointed, and your duties go towards the company.
You had a second question, Skonati.
The second question was...
appeal.
No, it was not about appeal. The second question was whether you guys should sit down with Peter Moyo and find an agreeable way to go your separate ways instead of litigating. Shouldn't you call him and sit down and say, please, sir, in God's name, go away. Here's whatever you want.
Okay, there are many parts to your question, Skonati. The one part of it is that I think unanimously the board would be of the view that that judgment is so bad for the company and company law that we have an interest in ensuring that it is overturned on appeal. That is not something we can walk away from. It's a corporate responsibility we have to all of the stakeholders of Old Mutual, but I would hazard to all of corporate South Africa, because that judgment creates, I know that it's marked not for reporting and so on, but it creates a massive headache in the corporate governance space. So we have an interest in ensuring that it is overturned on appeal. We can't stop that process. I repeat, we didn't want to get here. We didn't want to go to court. We were taken to court, and then we must defend the interests that we are required to represent as fiduciary responsibles for Old Mutual. That's what we have collectively as a board. And so the question, I mean, sure, every movie must have an ending, right? We don't know. We're waiting if the other player wants to call that thing out. But we've never said that we are opposed to closing out. We have massive letters from our shareholders. Ray, you want to see the letters from our shareholders that say, you can't put money on the table for this thing. Now, I mean, in some ways, we're going to have to find a medium to resolve this matter. I mean, we don't want to be held in neglect or in contempt by our shareholders, but we need to solve this thing in some way. I'm saying that the notice pay is 4 million rand. He's got it in his bank account already. I don't know what else he might expect. And I don't know what is reasonable and rational for somebody who's worked for the company for 2 years. But these are the big discussions that South Africa must have about how you square the circle in some of these things.
I'm just checking if there are any questions that we have received on our webcast or online. Nothing received on our webcast or online. I am going to take the last set of questions. Angelo?
Mr. Manuel, I'm going to pass you the letter that we received today from Moyo's lawyers. And point 6 is the point I'm making that hasn't, I think, been sufficiently answered. If you don't mind, sir, just...
I haven't seen the letters from Peter's lawyers.
I understand, sir. But I mean, this
I don't know if I can respond to oh, it's Bowman's.
Yeah.
Not Mr. Moyo's
Sorry,
lawyers.
my apologies.
I think this is awkward grammar.
I apologize for laughing, sir.
No, but it is awkward grammar.
That was the point of my first question, because it appears that he is to work, or carry on working, but work from home, the way I understood it.
Your client has stated that he considers himself obliged to tender his services. Craig, do you, I mean, I see this now, so please.
Chair, the letter. Angela, that letter has an annexure attached to it, which is Annexure A. The preceding paragraph, paragraph 5, refers them to it, and it effectively sets out Old Mutual's position as was set out in the letter that was distributed on Sunday evening to Mr. Moyo and his attorneys, which is effectively until such time as the second notice of termination is set aside, he's not required nor permitted to return to work, and that notice stands and remains valid. So what we're trying to do in that letter, if you read the letter in its entirety, I think one needs to be careful not to pull out piecemeal. But if you read the letter in its entirety, it's to land that message and also to say the reason that Old Mutual has elected not to rush off with further court litigation this week is that as far as we are aware and as far as we are advised, the Mashile judgment, which is pending in possibly a week or so's time, may deal with the second notice, it may not. It may deal with the contempt, it may not. For Mutual to rush off to court this week, the board's decided would be just to ramp up unnecessary time, pressure and costs, and would be irresponsible in the circumstances where we're trying to get things back on an even keel and just ensure that people are acting rationally and logically. It would just add unnecessary heat into an already volatile situation. So I'll happily make a copy of the entire letter. If you'll see that it does refer to an Annexure A, and if all they've leaked is if all they've released, poor choice of words, if all that they've released is the one letter, I think you need to read it in its entirety as a letter together with the annexure that it refers to.
Thanks.
Ladies and gentlemen, that concludes our proceedings for today. I would like to thank...
What are you doing with the webcast?
There were no questions on the webcast, Chair.
Oh.
There's no questions still?
Hi, Tabby. On the webcast, we still have no questions.
Thank you very much. One last question.
I just wanted to just double
Sorry,
check.
if you can identify yourself, please.
My name is Dineo Fagu from the Business Report newspaper. One of the things Mr. Moyo had initially said was that one of the directors had whispered to him that the board was gunning for him. May I just have your comment on exactly, how that happened? That were you gunning for him? Thank you.
Dineo, I'm afraid your question can't be answered. Unless we know who that board member is, the question can't be answered. I said earlier that in the way in which Peter Moyo's notice of motion and affidavit were put together, it's replete with untruths. It's replete with untruths. So why do you think that this is a truthful statement? And why do you think it should have any veracity or take up any of our time? I don't know that.
Thank you, Chair.
Okay, thank you.
Another one, okay.
I was just wondering, do you have to settle all the court cases and whatever before you can appoint another chief executive officer? Or how would it work now in terms of your executive?
Well, the challenge has been, and in our papers, we, in response to the initial application, we were abundantly clear that we are ready to rock and roll. On the board has worked through the terms of reference for a chief executive, takes all the learnings into the process going forward. It, with the human capital director here, as clarified the matters procedurally, in Judge Mashile's judgment, he says that we can't. It's a rather strange kind of situation. I'm saying that the act is abundantly clear on the responsibilities of directors. And one of the key responsibilities that a board has is to appoint a chief executive. And the judge takes that responsibility away from us, and it's an odd thing in the context of company law. And I go back to Skonati's question. We are duty-bound to appeal that kind of judgment. Because if you take a board imbued with responsibility and accountability, and you get that overturned by a single individual who happens to wear a robe, I think you have a bit of a difficulty. We must take that matter on appeal. But until then, I think that we are unfortunately hamstrung by the judgment, because it'll be kind of in your face to proceed in the face of this. We've been very careful to comply with the judgment to the extent possible, but we also are very clear about our rights. So the second notice is about our rights, not about violating judgment. Sorry, do you want to clarify the expedited appeal matter?
Before you move there, Mr. Manuel, I think you need to withdraw this statement. An individual who happens to wear a robe, you've already been charged with court of contempt. Contempt of court.
No, I think it's quite important to look at the context, because the judge doesn't afford us in the context of the Companies Act rights and responsibilities. It's for that reason that we have to take that matter on appeal.
But your board has already been charged with contempt of court.
We haven't been charged. There is a view by Peter Moyo and his lawyers that we are in contempt.
And you are saying an individual who happens to wear a robe in reference to a court.
Yes.
I submit that.
Okay, I withdraw.
Thank you, Your Honor.
Okay, thank you very much.
Sorry, wasn't there a question of loanies that was in play? You're okay?
You
okay.
responded to. Okay.
Thanks.
Ladies and gentlemen, thank you very much. That concludes the proceedings today. As you are aware, there are some one-on-one engagements that have been arranged through Magna Carta. So I would like to thank the board and our entire EXCO for today's proceedings, and end off by saying, have a good Friday the 13th. Thank you.